Okay. So nothing else on the motion for the sham pleadings? Okay. Ms. McLeod, anything on that motion?
No, Your Honor.
So a motion to strike does need to be made before you respond to the pleading.
I'm sorry?
It needs to be, that motion would need to be made before you responded to their complaint. That, hey, the allegations in your complaint are a sham. Typically, they would have an opportunity to fix that if the motion was granted. You filed your answer, you waived that issue. But even if we get down to the merits of it, what you're really seeking is a determination on the issues. You're asking me to resolve a factual dispute. Was he in possession? Was he not in possession? Could he have been in possession? Does this rental agreement have some impact on his ability to possess? Those are the kind of things that you've raised in this motion. And that's evidence, again, outside the pleadings. It's evidence that's going to have to come in through the fact-finding process of either a trial or perhaps another motion, not one to strike, or one to dismiss. A sham pleading in this sense is one that's false, in fact, on its face, which means looking at it, we can tell that it's just wrong. It's not pled in good faith. Not that there is a dispute about the facts or that you have other facts that make it look like it's not true, or even other facts that make it not true. That's a different kind of a motion that would need to be raised. It's not a sham pleading. So, again, I'm going to deny that motion for that reason, which moves us on to the motion for plaintiff's verification of complaint. And this is essentially the same, or at least very similar to the motion to prove representation. At least that's how I feel. Would you disagree with that, Mr. Dyke? Do you have any additional argument you want to make on that?
I think I've already made it.
Okay. Ms. McLeod, any additional argument on that motion?
No, Your Honor.
Okay. And I'm going to deny that motion for the same reasons I denied the previous. Go ahead.
Why is it unreasonable or unjust?
What I would say is that it's inappropriate under the rules. There's no legal authority for you, at least in this fashion, to seek that they've got the written consent of the plaintiff. By them signing their pleadings, they're stating that they do. If it turns out they don't, they're going to be in huge trouble with the bar. That's on them. I don't think that's an appropriate request, whether it's discovery or motion or however it's made.
Even in light of them already purporting to represent Mrs. Byers.
And they've cleared that up that was an error.
I did not have an opportunity to question them and verify that.
To question
the attorney.
And you don't have an opportunity to question the attorney. You can certainly question the witnesses, and we can get to that if we ever get there. Then let's see, the motion to reverse denial and grant hearing on defendant's December 31st motion to dismiss. Any additional argument on that?
Well, they didn't respond within the 10 minutes. I had prepared diligently to present this, and I didn't have an opportunity.
Ms. McLeod, anything on that motion?
No, Your Honor.
Should I get something
So
else?
if a person sues under an unregistered business name, and the defendant in murder says, "You don't have that name registered," the judge would say, "Well, they don't say they don't have the name registered in their complaint, so even though you say they don't have their name registered, it's irrelevant." If you look at Howard, well, there are cases.
That's a different motion than the one you're bringing.
Right, it was a 4A form.
That would be the party in interest. What you're saying is he doesn't have the facts to make the claim that he's making, not that he doesn't have the ability to make that claim. Those are two very different motions. In any event, with regard to this motion to reverse the denial, first there's no such motion in the ORCPs. Frequently, however, people do file motions, what they style as motions for reconsideration, which also don't exist, but are occasionally, for various reasons, permitted. Even if this had been styled in that fashion, I would deny it. The motion that was made back in December was this essentially on claims 2 and 3 that the plaintiff doesn't have possession, therefore he can't sue us for ejectment or trespass, which might very well be a valid defense, but it's not an appropriate subject for a motion to dismiss. So I don't see any reason to go back and reconsider that motion. Frankly, if I did, we'd end up in the same place. It's not the appropriate subject for a motion to dismiss. So I'm going to deny that motion as well, and I think that covers all of the currently outstanding motions.
What about a motion for summary judgment? I think you indicated that in the last. Is that appropriate for our consensus about possession?
If someone makes a motion for summary judgment, we review it.
I don't want to waste your time.
And I appreciate that, but I also can't provide you with legal advice on how to proceed or what might be appropriate or not. That's a job for an attorney.
Your Honor, in your order, you suggested that they could submit a revised motion to the
for their limited judgment, because I wouldn't sign the one that they submitted.
So if I understand something that you don't approve, can you hint at what you might approve, like you did for her?
If you were to submit an order or a judgment that ultimately you're asking me to sign because it reflects some ruling that I'm making or some decision that I'm making, and I don't think it accurately reflects that, I think that is within my purview. That's different than suggesting to you what motions you should or should not file. I recognize that I'm drawing some fine lines, but I need to. I have to.
I don't know how you can do it.
You're not the only person that probably feels that way at times. Ms. McLeod, anything else that you think we need to address today?
I think that is it, Your Honor.
Okay. Mr. Dyke, anything else that you think we need to address?
I anticipate trying to go through this whole discovery thing has been vexatious and very time consuming. Is there any way to can we disengage and say, we don't want any more hearings, we just want to go to trial with what we have? Is there an option we have at some point to say, we're tired of wasting Stewart Title's money?
So, that's an interesting question. I think you could, if both sides agreed that, look, we're just going to head to the courtroom and figure out what we're going to do. I can't compel anyone to adopt that position at this point because the parties are entitled to discovery. You're entitled to depose witnesses. They're entitled to do that. You're both entitled to request documents. You have done that to some degree. I don't have the authority to just say, look, we're done, we're not doing any more of that, we're just going to go to trial. So that's not an option that I've got. I could, if both sides are willing to and think it might be beneficial, attempt to get another judge to hold a settlement conference on this. And what that is, I know Ms. McLeod knows, Mr. Dyke, mostly for your benefit, and Ms. Dyke too, sorry, I keep doing that, I apologize. It's essentially a mediation that's led by a judge. It's not binding. Both sides have the opportunity to submit to that judge limited information. The judge isn't going to make a decision, so the judge doesn't need all of your evidence. But the judge does need letter, 2-3 pages, just kind of explaining what you believe the facts are, what you believe that evidence will show, what you'd be willing to accept as a resolution, what you think is a fair resolution, those types of things. And I think all 4 judges in this district use the same letter to request that information, so it's generally that type of information. Then you sit down with that judge, and he or she will spend some time bouncing back and forth between the parties with proposals and see whether or not a resolution can be reached. I think those are beneficial where the parties have at least expressed some willingness to consider resolving the case.
We have it.
What a judge can do then is at least provide you some insight as to at least what that judge thinks. And of course, it's not binding on a judge that might ultimately hear it if it goes to trial. It's certainly not binding on a jury if ultimately it becomes a jury issue what that one judge thinks. But it can be a quicker way to resolve a case, and obviously directly related to that is less expensive. So that's an option I'd throw out there if you're willing to consider it, and I can see if one of the other three judges might be willing to do that for you. There is, I think in a civil, is it $100? It's in that ballpark. Might be $200. Let me check, since I've got that here somewhere. Fees.
I just completely regret that we didn't have 5 minutes. If you and the plaintiff had 5 minutes to come and talk to you in the beginning before all this blew up, wow, all this might have been entirely unnecessary.
Let's see, settlement conference in a civil proceeding, which this would be, it's actually $210, it's gone up. And that would be a fee that you could apply to have waived if you would otherwise qualify for a fee waiver, which you may or may not, I don't know. So if you're willing to do that and plaintiff's willing to do that, I can see if we've got another judge that's willing to hear it.
Your Honor, we'll need to discuss it with our client, and then I would assume that we could file just a very brief stipulated motion if both parties did want to do that.
That would be fine with me, and if you do that, then we'll get to work on rounding up a judge. I would like to put this on for a status conference at some point, let's say about 60 days out, just to make sure it's still moving. Looks like I might have to go longer than that, given my trial schedule, but not a whole lot. May 22nd, does that work? It'd be at 8:30.
That's fine, Your Honor.
No, yes. She thinks it's fine.
Okay. If for some reason it turns out it's not fine, get a hold of us, let us know, and we'll work on getting it rescheduled. Ms. McLeod, you said that did work for you?
That's fine, yes.
Okay. So that'll be the game plan. We'll have a status conference then, hopefully in fairly short order. If you folks are all willing, we'll have a stipulated order for a settlement conference. I'll start working on getting somebody on board, which should happen very quickly once I've got that order. And then we'll try and get a settlement conference set if that's where we're headed. And hopefully that'll give you the 5 minutes, Mr. Dyke, to try and get it worked out with any luck. All right, thank you folks all very much. We're in recess.